Green card holders in the United States are facing increasing concerns about the risks associated with international travel, especially under the policies of the new Trump administration. This issue has created uncertainty for many individuals who are unsure about their ability to move freely in and out of the country. The risks involved in traveling as a green card holder are not straightforward, as they depend on various factors, including the length of time spent abroad, the country of origin, any prior criminal history, and the extent to which residency requirements are maintained. Understanding these factors is crucial for green card holders who wish to protect their immigration status while traveling internationally. One of the primary considerations for green card holders when traveling is their residency requirement. A green card is granted to individuals who intend to live permanently in the United States, meaning that the U.S. government expects them to consider the country as their primary home. Although green card holders are allowed to travel abroad, they must ensure that their trips do not give the impression that they have abandoned their U.S. residency. There is no absolute restriction on international travel, but extended periods of time outside the United States can raise concerns. If a green card holder remains outside the country for more than 6 months, but less than a year on a single trip, they may face questioning from Customs and Border Protection (CBP) officers upon their return. CBP officers may suspect that the individual no longer considers the United States their primary residence, leading to further scrutiny and, in some cases, even the potential revocation of their green card. If a green card holder stays outside the United States for more than 1 year without obtaining a reentry permit, they risk losing their green card status entirely. Such a long absence strongly suggests that the individual has abandoned their residency in the United States. To prevent this, green card holders can apply for a reentry permit, also known as Form I-131, which allows them to remain outside the country for up to 2 years without jeopardizing their status. This document serves as proof that the individual intends to maintain their U.S. residency despite extended travel abroad. However, in order to apply for a reentry permit, the green card holder must be physically present in the United States at the time of the application. It is not possible to apply for the permit while already overseas, making it essential to plan ahead and submit the application well in advance of any extended travel. Another major concern for green card holders traveling under the new Trump administration is the heightened scrutiny they may face when re-entering the United States. There has been a noticeable increase in the level of attention CBP officers pay to green card holders at the border. Officers are now more vigilant in assessing whether green card holders are genuinely residing in the United States or if they are simply using their green cards as a backup option while living in another country. Some individuals maintain property, bank accounts, and family ties in the United States, but actually live and work abroad. This can lead to intense questioning at the border, with officers requesting proof of employment, bank statements, utility bills, and other evidence of continued U.S. residency. A real-life example highlights the seriousness of this increased scrutiny. A green card holder who had spent the majority of the past 2 years abroad was pulled into secondary inspection upon re-entering the United States. CBP officers questioned them for over 4 hours, demanding proof of their ties to the country, such as employment records, property ownership documents, and bank activity. While the individual was ultimately allowed to keep their green card, they received a stern warning and were flagged for future inspections. This case underscores the importance of being prepared to demonstrate strong connections to the United States when traveling as a green card holder. Beyond residency concerns and increased border scrutiny, there is also the potential risk of new travel bans being implemented under the current administration. During the previous Trump administration, executive orders were issued to restrict travel from certain countries deemed to pose national security risks. While green card holders were eventually exempted from these bans, there was a period of confusion and uncertainty during which many were stranded overseas. If similar travel restrictions are introduced again, green card holders from affected countries could experience delays, additional inspections, or even temporary restrictions on re-entering the United States. For example, if a green card holder travels to a country that is later added to a travel ban list, they may be subject to heightened scrutiny and vetting upon their return. In some cases, they could even be temporarily barred from re-entering the country until the situation is clarified. This highlights the importance of staying informed about any new travel restrictions and being prepared for potential disruptions when planning international travel. Another significant concern for green card holders traveling abroad is the impact of criminal convictions on their admissibility into the United States. Even minor criminal offenses can pose a serious risk, as certain violations can render a green card holder inadmissible, meaning they could be denied re-entry despite having a valid green card. Crimes involving moral turpitude, such as fraud or theft, as well as drug offenses and DUIs, are examples of violations that can trigger inadmissibility. Green card holders with criminal records may face additional scrutiny at the border and, in some cases, may even be placed in removal proceedings.